as soon as practicable, inquire into the matter and process the complaint for conciliation and refer to the tribunal. Now, the term procedure speaks to a series of sequential steps, and these are used to respond to a series of problems. Now, before the first schedule can be really activated, what the ERA seeks to find out is that under Section 29 of 4B, whether or not the dismissal was fair or unfair. And Section 4B states that it depends on the employer complying with Part A of the fourth schedule. However, before we get into the real meat of the matter, I would just like to clear up a few misconceptions. Some persons use unfair and wrongful dismissal synonymously. They are different in their application. Unfair dismissal is based on the contravention of the country's employment law, in this case, the Employment Rights Act. Any claim for unfair dismissal must be done through the Employment Rights Tribunal. Whereas wrongful dismissal is determination where there has been a breach of one or more terms of the employee's contract, and this claim is done through the court. It is a legal procedure. So the fourth schedule gives the employers the methods to be used when disciplinary matters are being contemplated against an employee. And it takes into account, as I said before, Sections 29 4B, which states that the employer must have complied with the rules set out in Part A of the fourth schedule, and this is important in determining if the dismissal was a fair one or not. So the fourth schedule at Part A states that disciplinary matters should be done progressively except in the case of gross misconduct. And gross misconduct relates to the conduct of the employee. And this would be like when an employee commits an act that destroys the relationship of trust with his employer. And it might be deemed to be so serious that it's impossible to continue the working relationship. Elements or examples of gross misconduct would be stealing, fighting on the job, employment sexual harassment, falsifying data, sleeping on the job, especially in the case of security officers and persons operating machinery, and disobeying a lawful request from management. These are the things that will constitute gross misconduct. So Part A speaks to progressive discipline. Part B speaks to transparency in proceedings, and the modified disciplinary procedures would look at when a person is summarily dismissed, he still has a chance to appeal the decision to terminate him. So transparency, how will it change how will the fourth schedule change the IR landscape or the industrial relations landscape? It will speak to specific issues such as transparency, fairness, level-headedness, determining the difference between a just and an unfair dismissal. What should employers and their representatives do? They should consult the ERA before disciplining employees. If in doubt, they should call the labor department. They should consult with their HR department and look at their own standardized operating procedures or utilize the employee handbook. This dismissal and disciplinary procedures part Progressive disciplinary action would be that if a person was tardy or did not meet the expectations of the company, he should be either given an oral warning or a verbal warning. However, in cases where persons will not have met the expectations of the company, probably in the production line, there should be some form of coaching, training, or retraining of the employee. Things like performance appraisals should be used to help the employer and the employee understand what is needed in the company. Therefore, the ERA Part A would not ask you to terminate a person just like that. However, as I stated before, the exception will be for gross misconduct. So, written warnings should be used extensively if they are to be given. And then there is an expungement period. So if a person has been warned, about his behavior, and the behavior would have occurred, that warning would have occurred between, let's say the person was warned on the 16th of October, and there has not been any other occurrences by the 15th of October next year, that warning should be expunged from his record. As a matter of fact, it cannot be used against the person after 1 year. Part B of the disciplinary procedures asks management to state in writing the grounds for actions and invitation to a meeting. So therefore, if an employee would have had an infraction that merits a disciplinary action, his misconduct should be stated in writing, the date that it occurred, and this should be transmitted to him in a statement. The statement should also allow him to bring a representative at the meeting if the representative is a trade unionist or can be a friend. The meeting should not take, no action should take place before the meeting is called. And the meeting should be called preferably within 7 days of the alleged misconduct. So what it does, the statement, give the statement to the employee and invite him to a meeting and a representative to come also, but it gives the employee a chance to respond or to mount a defense in his own case. So let me just recap that there must be a meeting before disciplinary action, and that the meeting should be held within 7 working days of giving the employee the statement. The employee should be informed of his right to have a representative at the meeting, and within the statement given to him should be what grounds there were for having the meeting. Part B, standard disciplinary procedures. Notification of the decision and a notification of the appeal. What it speaks to is that after the meeting would have been held and the decision to terminate the employee has been made, the employee should be notified of the decision in writing and given the reason for the termination as well. And management should give that person a chance to appeal the termination. The Act does not give a specific time, but a reasonable person would expect that an appeal will be done within probably 5 to 7 days of the actual termination. Moreover, the persons sitting in on the panel. Moreover, the persons on the panel should not be the persons who you should appeal to. Before schedule continue, we are looking now at Part B, Step 3, the appeal. The appeal must be done in writing. And after the appeal and the decision is still upheld with regards to determination, the employee then can make a referral to the Chief Labor Officer. And this is done, as I would have stated earlier in my introduction, under Section 8 and 42 of the Employment Rights Act, and the person must be working for at least 1 year, and the complaint must be made within 3 months of determination, of the date of determination. So the question might be asked, why should you adhere to the fourth schedule? One, it offers accountability. It saves time and money, and it gives due process. Where accountability is concerned, the accountability will come in you providing the employee, the affected employee, with a statement with regards to the misconduct. Saving time and money in the event that the complainant comes to the Labor Department and makes a claim for unfair dismissal and the procedure was not followed, then the claim would have a form of validity. As regards to due process would be showing that there was transparency in adhering to, in dealing with the employee and in adhering to the rules as set out by the fourth schedule. We will now move on to the fifth schedule, which relates to compensation. And it speaks to the basic award that are to be made in the case where a person has been unfairly terminated. Under Section 37(1)(a), there can be an order for reinstatement or re-engagement at Section B, or no reinstatement or re-engagement. It also speaks to, the fifth schedule also speaks to various levels of compensation. There is the basic award, what the tribunal takes regarding benefits, and wages for 52 weeks. These are under the fifth schedule. There are a series of compensations starting from when a person is working for less than 2 years. So Section 2A speaks to 5 weeks wages for less than 2 years. Section 2B speaks to 2.5 wages for each year for 2 years, but up to 10 years. Section 2C speaks to 3 weeks wages for 10 to 20 years. And D says that 3.5 weeks wages for 20 to 33 years. However, there, Section 3 speaks to completed years, and any continuous employment beyond 33 years will not count. In addition, any monies paid by way of severance will be deducted for the final payment. Any payments that were made on the grounds of redundancy made by the employer to the employee will be also deducted. So we get to this segment now, what can managers do to avoid having to pay away large sums of money in an unfair dismissal claim? More attention must be paid to natural justice, due process, the employee handbook, and most importantly, progressive discipline. There must also be consistency in applying disciplinary procedures. What obtains for Mary must also obtain for Jane. Performance appraisals, as stated before, are very, very good ways of bringing employees up to standard. It is a democratic way of getting accountability, and employees can also have their say in challenging anything that is said or done or written about them that does not resonate with them. Then there's the standard operating procedures of the company. These should be utilized. And there should be a need to reduce, to retain everything that is being done. Good morning again, ladies and gentlemen. Let me apologize. We had a technical glitch there just now. And I was at the stage of speaking to how managers should apply disciplinary procedures. I was at the point where we were speaking to how managers should employ disciplinary procedures. And we were recapping what they should do. Okay, so I will back up a bit since we had that technical glitch. All right, I will go back to the fifth schedule regarding compensation, and it speaks to various levels of compensation with the basic award and what the tribunal thinks regarding benefits. So the tribunal will look at the amount of money that they think that a person would have reasonably expect to have earned, but because of the dismissal, they did not earn that amount of money. However, it will not be an amount exceeding 52 weeks, where the dismissal was for a specified reason as set out in section 31C, or where there was more than one reason for the dismissal. One of these reasons must be specified. So the fee schedule and compensation, section 22A speaks to 5 weeks for persons working less than 2 years. 2B speaks to 2.5 weeks wages for years between 2 to 10 years. Section 2C speaks to 3 years wages for 10 to 20 years. And D, 3.5 weeks wages for 20 to 33 years. It should be noted that it speaks to completed years. Any continuous employment beyond 33 years will not count. In addition, at section 5A, any monies paid by way of severance will be deducted from the final payment. And any payment made by the employer to the employee, whether in pursuant of the severance payment act or otherwise, would be deducted also. What can managers do? Managers need to pay attention to natural justice, due process. They should consult the employee handbook. And most importantly, they should follow section part A of the employment of the fourth schedule, which speaks to progressive discipline. Moreover, there must be consistency in applying disciplinary procedures. They should also utilize performance appraisals as a way of either tweaking the demands on the worker and getting feedback on how things can be best done. They should look at standard operating procedures, and they need to reduce to writing things like warnings and so on. Rather than utilize verbal warnings, they should utilize written warnings. The Labor Department understands that small businesses might not be able to afford or have at their workplace HR departments or even industry relations consultants. What I would advise, or the Labor Department would advise, that persons working as HR consultants or industry relations consultants can be utilized on a contractual basis to solve some of your problems really as it relates to discipline. There needs to be clear communication to the worker of exactly what is to be done. And if there is an HR department, consult with your HR department before making decisions to terminate employees. So managers can use the procedures to help and encourage employees to improve rather than impose punishment only. Inform the employee of the complaint and provide an opportunity to state their case before decisions are reached. Allow the employees to be accompanied at disciplinary meetings. This really is mandatory. The law says that a friend or a representative should be at the disciplinary meeting and make sure that disciplinary action is not taken until the facts of the case have been established and the action is reasonable in the circumstances. Never dismiss an employee for a first disciplinary offense unless it's a case of gross misconduct. Give the employee a written explanation for any disciplinary action taken and make sure that they know what improvements are expected. Again, the performance appraisers can speak to this. Give the employee an opportunity to appeal and deal with issues as thoroughly and promptly as possible. In addition, you must act consistently. What obtains for Jane should also obtain for John. There should be no favoritism because it can lead to problems within the workplace. We have come to the end of this course, this presentation, and they can be contacted at 535-1509 or by cell phone 832-0586. Thank you. We now await your questions. Alicia Trotman, you would have asked a question: when prepare a letter to invite an employee to an investigative meeting, is it correct to use the terms "you're invited to an investigative meeting to discuss"? I was previously told by a labor officer that there is no such thing as an investigative meeting. Therefore, my question, it should be rephrased to state you are invited to a meeting. What the letter of invitation should state. What the letter of invitation should state, the infraction that was done by the employee, indicate that you are invited to a meeting to discuss this infraction that occurred on such and such a date. The letter should contain also that you are to bring a representative to the meeting, whether it be a friend or a trade unionist if the company is unionized. That is how the letter should be written. If there is going to be an investigation into a matter, what the company can do is suspend the person with pay pending an investigation. And then the letter of invitation will reveal what the allegations are after the investigation, and it will contain the same things, the same elements of inviting the person to the meeting with a representative. I hope that answers your question. Earlier, someone wanted clarification between wrongful dismissal and unfair dismissal. Unfair dismissal is when a dismissal has been done that contravenes the employment laws of a country. In this case, it would be the Employment Rights Act. If the procedures as set out in the fourth schedule are not adhered to by the employer, then the complainant, the affected employee, can bring a case of unfair dismissal, and this will be brought through the Chief Labor Officer. And if there's no resolution, then it can go on to the Employment Rights Tribunal. In case of a wrongful dismissal is predicated on when one or more components of a contract has been breached by management, and this is normally done through the law courts. So this would be more or less a legal procedure. So unfair dismissal is predicated on not following the procedure as set out in the Employment Rights Act, whereas wrongful dismissal is for breach of contract or contractual obligations and will be dealt with in the law courts. As I would have stated earlier, another question would have been asked as to the period for expunging any warnings from a person's record. The period is 1 year and not 1 calendar year. It will be determined from the time that the infraction was committed. So if the warning occurred on the 15th of July, by the 14th of July of the following year, that infraction should be, or that warning should be expunged from the person's record. I'm saying Grace Frederick here. Could you state your question, please? Grace Frederick, could you state your question, please? Okay, I'm not hearing from Grace Frederick. Kalisa Mahon, state her question, please.
Hello, good morning. Can you hear me?
Yes, I'm hearing you loud and clear.
Hi, good morning. I have two questions. One is if you invite an employee to a disciplinary hearing and you've made a typographical error, for example, you've put 18th December 2019 as the date of infraction instead of 2020, and this comes out in the disciplinary hearing, can you then, as an employer, invite the employee to another disciplinary hearing to address the same issue with the correct date, or would they consider that it was already addressed and it was your fault that you made an error?
No, but okay. If it was a typo, you can apologize for the typo and continue the meeting. The typos occur on a fairly regular basis, and even at the court, if there is a typo with the name of the person, it can be amended to suit or to correspond to the correct name. In this case, the typo can be amended to correspond to the correct date. It wouldn't have any bearing on the substantive issue that will be dealt with.
Okay, Okay, thank you. And the next one is if an employee makes a complaint against another employee, let's say for using abusive language or something like that, and during the investigation you find that the complainant also admits to using abusive language, is it permissible for an employer to then charge the complainant as well for violating a company policy?
Well, you should go to the company's rule book and see what the sanctions are. And in that case, I will give both of them a warning. If the rule book states that there should be a warning, well, then you should follow what the rule book says. So okay. What is your policy in regards to using abusive language on the job?
Well, our policy is a written warning.
Okay, so then that should be utilized.
So I would still have to invite both of them to a disciplinary hearing, though.
But I am under the impression that they were at a disciplinary hearing when it was revealed that both the complainant and the accused person used abusive language. If that is the case, they don't have to set a new date. You should deal with it there and then and give the warning.
Okay. It would have been during the investigation that we found out that the person who made the complaint, when we were getting their statement, we would have found out that they also used abusive language. So I'm just
what can be
wondering.
done? Okay, in that case, since you were doing an investigation and it revealed that both persons were using abusive language on the job, then a letter invitation should be sent to both of them, or you can just invite them in to discuss the matter and issue both with a written warning.
Okay, thank you.
You're welcome. Any other questions? Okay, since we are waiting for other attendees to formulate questions, I'm seeing Abon Quichlaw. Could you go ahead and state your question, please? Could Abon Quichlaw state your question? I'm saying Abon Quichlaw. Could you go ahead and state your problem or question, please? All right, Grace Frederick, go ahead, please. We seem to be having some technical glitches again. Let me apologize on behalf of the Labor Department. I'm not hearing Grace Fredericks nor Quichlaw. Zola Sears, could you come in, please? Could you state your question?
Hi, can you hear me?
Yes, I'm hearing you loud and clear.
Okay, great. I just wanted to ask if you want to rate up an employee on, let's say, an infraction, sorry, and it's let's say you're not giving them a warning or anything, but you do want to like have a meeting with them. What's the procedure for that?
But you said that first of all, you have to state the level of the infraction and go back to your employee handbook. That would be your best guidance. So what was the level of infraction that you're talking about, or is this a hypothetical question?
The level of infraction would be, I would say it was a minor thing. Like, let's say they were supposed to do a task and they forgot or made a genuine mistake, but you know.
But therein lies the solution. You said that they would have forgotten to do a general task or made a genuine mistake. If they would have made a genuine mistake, probably a verbal warning would suffice. That might be to me, the highest level of discipline that you can use, since the person did not willfully forget. The person just forgot, as you would have said. So in that case,
do you
pardon? Yeah,
do you just rate them up, or do you actually, have a meeting and ask what happened? Do you,
Well, I
because this
guess
goes back
that,
to the same.
okay,
Mhm.
what I'm getting coming to is that the person would have forgotten to do a particular task. You would have observed that during the course of the day or whatever, that the task was not done. It might be better to call the person and ask them why the task was not done. And then if you discovered that there was a genuine mistake, then you can just give them a verbal warning. So you don't need to really reduce that to writing.
Okay.
Okay,
Okay,
you're
just
welcome.
wanted to be clear on the procedure. Thank you.
You're welcome. Kyle Griffith, could you go ahead with your question, please?
Hi, good morning.
Good morning, sir.
Now we're in the era of the pandemic. We have a lot of situations where you have employees working from home, and the business took the stance to somewhat change the time schedule because you're actually home. You don't have to get up and leave your premises. But then you find employees still have a kind of a tardiness aspect going on with starting work. Your company still has a policy for tardiness. How then would you address a situation where you're working from home and still you're responding to your work situation late? When you ask the question like, why did you take an additional 15 minutes after you're supposed to start work to answer an email? Or I got calls from another department saying I was trying to reach you and you did not respond during working hours.
All right, I guess that the same procedures for working at home can be applied. The same procedures for working from the office would be applied to working from at home. However, you did state that the times would have changed, and I would hope that the changing of the times would have been done with the consultation of the workers rather than the company unilaterally changing the times of the workers. However, if persons are still tardy, even though they're working from at home and they have check-in times to verify that they are online, then the company can utilize its policy manual in regards to lateness or tardiness and issue either a verbal or a written warning to the employee. Does that satisfy you, sir?
Yes, thank you.
I'm seeing Charlene Innes.
Good morning. You can hear me?
Loud and clear.
Okay, great. So my question is related to progressive discipline, and really if there is a situation where, as part of your discussion with an employee about a particular behavior, you do not want to necessarily give them a verbal warning. Before you do that, you are actually sending them a letter documenting the behavior you've seen and indicating that what you expect from them. In a situation like that, and you are having a discussion, is that employee allowed to bring a friend or representative? You are not issuing a verbal warning, you're having a meeting, and after the meeting, you're documenting having discussed this matter, but you're not actually issuing any warning.
All right, to answer that, part A of the force schedule speak to progressive discipline, but it did not speak to bringing a representative with you. Part B speaks to bringing a representative with you for a disciplinary meeting.
Right.
If it is going to be a discussion about behavior or production
Yes.
the level of production.
Correct.
That can be have on a one-on-one without having to resort to bringing a representative.
Right. So you have that meeting and you document it in a letter, but it's not a warning letter or anything. They want to discuss that letter. Are they allowed to bring anyone?
But that would be up to management. As I said, Part A of the force schedule does not state specifically that you can bring a representative. Just speak about progressive discipline. If management believes that the person can bring a representative, they can do so. But it does not specify that during the act of progressive discipline.
Okay. Thank you.
You're welcome. Are there any other questions, please? Are there any points that persons will need any further clarification on? I'm saying, Shirley Ennis again, could you pose your question, please?
Yes, so this is like a follow-up question. In the case of, is there, in that letter, and you're saying to the person that if the behavior continues, they will then be disciplined. Is that considered a warning? So you're saying,
I'm listening.
because someone had said that once you use warning, it's a warning letter. But if you're saying that you will start disciplinary proceedings if this behavior does not improve, it's not.
First of all, tell me the type of behavior that you are speaking to, because I'm a bit hazy as to the type of behavior that
So if this is someone that is say an example, you are given a task and you're always completing it after the deadline, and you've had discussions, but you are at the point where you're not necessarily starting a disciplinary proceedings against the person, but you are meeting with them to say this is behavior that has been noticed and that you want to see an improvement. And if there is no improvement, then disciplinary proceedings will start, which will include a formal warning letter, etc. One of my colleagues was told that once there is any reference to warning in the correspondence, it is a warning letter. So that's my thing. You're not actually giving them a formal warning in terms of starting the disciplinary proceedings. You're simply saying that if the behavior continues, that is what will happen.
All right. Now, the law speaks to either an oral warning or a written warning.
Mm-hmm.
So you can note on the person's file that an oral warning was given on such and such a date in relation to whatever infraction it was. In this case, it seems to be the ability of the person to perform the task in a given time. And that can be noted on their record.
Right.
I'm saying Emerson Bourne. Go ahead with your question, please.
Going back to the previous, you can hear me?
Hello?
Can you hear me?
Go ahead. Yes, I'm hearing you.
Going back to the previous question, you asked to come to a meeting that just supposed to be a discussion. But when you get to this meeting, you realize that the HR manager, maybe say the manager of employment relations, and the person's supervisor, remembering it's just supposed to be a discussion, could that employee ask or start the meeting under intimidation to have a representative?
First of all, if
Because it's supposed to be a discussion. So whatever the discussion,
all meetings, but by a meeting can be reduced to discussion. So a discussion and a meeting are one or about the same thing. What I think what management should do is if the person is, if they want to talk to the person in relation to productivity, that a note can be passed on to them, asking them to come to a meeting to discuss their level of production or whatever. And it should be noted that it's not a disciplinary meeting. That might allay the fears of the employee about feeling intimidated. The HR manager or the supervisor would be there to point out the areas that the person was falling down in. And the person should feel glad that the supervisor is there so that they can challenge the person as to what they are saying about them. So it should not be a thing for intimidation. It is that a note was passed to the employee to come to a meeting to discuss their level of productivity and let them know that it is not a disciplinary meeting, but just a meeting to understand what is happening with the person in relation to their work.
okay, so maybe say the employee turned up at the meeting start, but then the employer realized that the meeting is going down a different road as opposed to what he was supposed to be there for. The language being used is not conducive for what he was supposed to be there for. What
Give me an example of going down a different road.
Example. Or let me say, as you said before, they were invited to discuss production in terms of your performance of how you perform. And then you realize that they're going back to incidences, maybe say 2 years ago, I'm bringing that up now in this discussion. Something like that.
Well, as I would have said earlier on, after a year, warnings for a particular incident should be expunged. So
after a year.
Right. So going back 2 years really is a no, and the person can object to that.
Okay. Okay, thanks.
I'm seeing Zola Sears.
Hi, hello.
Good morning.
Good morning. All right. Just kind of stemming from what he was saying, something that I remembered. If you have an employee and you basically received report from this person's, let's say, immediate supervisor, and the reports state that they should be disciplined for whatever it is that they were doing. It's against company policy, or it's an action that warrants some kind of disciplinary hearing or procedure, and you have a meeting with that person, but in the meeting, the person denies or just say that everything that the immediate supervisor is reporting is false. How then do you proceed?
You're saying that in the meeting that the charges against the particular persons were falsified by the supervisor?
That's what the employee is saying, yes.
Then the manager should bring a halt to the proceedings and do a thorough investigation of the whole matter.
Okay. All right. And after the investigations, then if it is found that the reports have been falsified, how then do you proceed? Do you just go back to your disciplinary procedures then to reprimand the supervisor?
Well, then if any falsifying information against an employee is a real, that's detrimental to the health and well-being, financial health and well-being of the particular employee. And if you're having persons in your management team falsifying information, then you need to take a serious look at that. You need to look at what your handbook and policy speaks to in relation to falsifying information. So if in your investigation, you would have found that the supervisor did indeed falsify the information, you would need then to take disciplinary action against that person by following the standards set out in Part B of the 4th schedule, in that you will write a letter stating the infractions, invite that person to a meeting along with a representative on a particular date, and have the meeting at the time and date listing the infraction against the employee. If as a result
one other
of
question.
Okay, go ahead. Go ahead, Ms. Sears.
Okay, what about, let's say you have a situation where that information was, let's say you have information brought to you in your meeting that you would prefer it to be presented a different way, or you would prefer, as people would say, for all T's to be crossed and all I's to be dotted, right? And you have a team of individuals who bring in this information. However, you write up the entire team for that one infraction or whatever for that one person. Is that the correct procedure? Or should you just maybe, like you said earlier, have a conversation with the person? It doesn't have to necessarily be reduced to writing. Can you just say
clear,
that, or is it something?
Right now, you need to be clear. I am not understanding the question.
All right. So let's say that you ask someone to bring in documentation of something. The documentation that you received, let's say it isn't completed.
But documentation in relation to what?
Like the same thing I was talking to you about earlier. Like you have a supervisor who's reporting something or bringing in documentation on a person or a situation. They bring in that information. It's not completed, right? So I can understand that would be an infraction. So you would write up or maybe follow some kind of verbal warning for that particular person that would have brought in that information incompleted. But I'm asking, is it correct to then extend that to the entire team of persons that would be responsible for doing the same thing? Can you do that? Or should it just be the one person that actually committed the infraction? I think what I'm asking is kind of pretty obvious, but I'm just trying to figure out if it's right to then address all the team members. You have a team of, let's say, 3 supervisors. Your 3 supervisors, one of them has an infraction. Do you rate up all 3 of the supervisors, or do you just rate up one?
But if the infraction is only related to one person, why write up all three?
Okay.
If
And then,
the infraction is related to a particular individual, but then the particular individual has to answer to those charges. If the person
okay,
is in
and
charge
they
of
should
a
go through the
team,
same procedure.
yes, you should. You should follow the force
Okay.
schedule part B.
Understood.
Okay, does that answer your question?
All right, thank you. Yes, it does.
Okay. Are there any other further questions? I'm seeing Kyle Griffith again. Could you state your question?
Hi. Yesterday in the session, we had a situation where they had the thing for the sickness, the sick part of the legislation for certified sick leave, non-certified sick leave. But you have a situation where an employee finds a way where they try to skirt the actual fact that you can stay home for 2 days, then go to the doctor, get the certified sick leave backdated to the day where you were home from when you started. You exhaust all of your, in that way you're not exhausting your actual sick days, but then you end up in a situation where you're home for more than 200 days out of a calendar year. In a case like that, how do you take the actual, how do you take measures against stuff like that? Because you have legislation on one hand saying things must run concurrent for 52 weeks in order for action to be taken, but then you also have some person that found a loophole that they could use just to be literally taking time from work every 2 weeks just to say, well, I stay home for 2 days, I go to the doctor, get a week home, I come back to work for 2 weeks, then they back home. In this case like that, how do you deal with something like that?
Well, first of all, I would like to know how you know that the person would have backdated the doctor certificate. But the law says that on the first day that you are home sick, you should call in. And on the second day, you should do the same thing. And if on the third day, you're still not feeling well, then you will go to the doctor and get certified leave. However, if you think that the person goes to the doctor on the third day and get it back there to the first day, I don't know how you will get around that. However, if there is a pattern of that going on within the company, it speaks to frustration of the contract one, and you should invite the person to a meeting to discuss his behavior or his pattern of behavior.
Okay, because to speak into how I would know, the person would obviously call in. I cannot report to work on Monday. Cannot report to work on Tuesday.
You did not state that first up, right? If the person calling on the 2 days, they are within the law. The law says that if the third day you're not feeling well, then you do not report for work. Then you should produce a doctor's certificate. If that is being done, by the person, I don't know how you would challenge that, but you're saying that the person will be staying home in excess of 200 days and so on. Well, then you have to deal with that because the person is not an asset to the company and it will be a frustration of your contract or the contract.
I understand that part, but as I said, you just clearly stated it'd be a frustration to the contract, but legally it is also comes with a loophole from the legality part of it.
I would have answered you as to how you should go about doing that. I don't know. I cannot give any further suggestions. I told you that one, the person is frustrating the contract. Two, if the person brings in a medical certificate, the person is within their right to bring in a medical certificate. But if you're saying that this is a constant occurrence, then it is a frustration of the contract and you should deal with it.
Okay.
Okay. All right. Since there are no further questions, I'm going to bring the session to a close. So let me thank all the participants. And here's wishing you a great weekend.